All right. Thank you for talking to us today, Mr. Kasim Gid. I'm the resident electoral commissioner for Adamawa State, bringing us up to speed, at least at the moment, concerning what they're thinking or what the plan is for this weekend, whether they will proceed or not. We're speaking about the courts and, well, what's going on with not just Adamawa State, with all the other states. You know, remember, you've got Bauchi, you've got some states, quite a number, that will be holding those supplementary elections. Well, joining us now to weigh in on the goings-on, we've got Jenny Agim, who is a legal practitioner, joining us from our studios in Abuja. Good morning, and thank you for joining us today. Let's straight away tell us, what do you think of the development at the moment where some states are not even sure whether or not they're going to go on with the supplementary elections this weekend?
Good morning, Chamberlain.
Go ahead.
Good morning, Chamberlain.
Go ahead. Good morning. I can hear you.
Yeah, well, good morning, Nigerians. I think it's important for us to know that elections in this climate, and particularly Nigeria, is highly regulated. And they are based and conducted by the laws of the land. And there are two primary pieces of legislation. That is the Constitution of the Federal Republic of Nigeria, 1999, as amended, and the Electoral Act 2010 as amended. And on the basis of that, any elections conducted in Nigeria that does not meet the requirement of these two primary legislation will be overturned or annulled at the election tribunals. And so it is the responsibility of INEC to ensure that when they conduct elections, these elections meet the threshold as set out in these two primary legislation, and including their electoral guidelines, the manuals, their handbooks, the code of conduct for political parties, for accreditations of voters and election observers. And so, in this instance, where INEC has gone ahead to conduct elections, and for some reasons these elections are cancelled or declared inconclusive because of the challenge of these elections not meeting this constitutional and legal threshold, it behoves on it to ensure that the right thing is done so that those who would challenge the election, don't forget, whoever is challenging the outcome of elections will always include INEC as a party so that they will be able to defend their position when the time comes, be it at the election tribunals or pre-election matters, as it were. So I believe basically that is the reason why INEC declares some of these elections inconclusive, because of these elections not meeting the required threshold.
Well, speaking about those required...
However, I think it is important for us to state at this stage that this is not the first time elections have been declared inconclusive.
Well, Mr. Agim, if I could jump in there, because I have some lawyers also speak about, I think some of them cite section 179, and they say, look, the requirements that's got to be fulfilled for a governor or elections to be declared, winner declared, elections concluded, is already stated there. So all of this margin of lead principle is unconstitutional.
Well, Chamberlain, I must say straight away that these positions taken by some of my senior and respected colleagues, I want to believe is not completely true, because the law is clear, both the Constitution and the Electoral Act is clear as to when elections can be declared inconclusive. And like as I was saying earlier on, you must agree with me that this is not the first time elections have been declared inconclusive. In 2009, we had the example of Ekiti. In 2010, we had the example of Anambra. In 2015, we had the example of Imo State, the Taraba State, Abia State, where elections were declared inconclusive. and reruns were conducted, and these elections returns of valid votes were made, and winners were declared. So this is not the first time, but I must equally say that in 2019 is the first time we are recording this high number of close to about 40 instances of inconclusive elections. We have 6 from the state governors' elections. We have 7 for senatorial elections. We have 24 for Federal House of Representatives, and I think 3 or so in the FCT when, during the conduct of the area council elections. So this is not the first time. And INEC is empowered by Section 53 of the Electoral Act to declare elections inconclusive in the event of whether there is violence, whether there is overvoting, and of course the current trend that we now have, which is the issue of the current lexicon that has been added to our electoral jurisprudence, which is vote buying. When INEC considers that any of these instances had happened, it behoves on INEC to declare the election inconclusive in the polling units where this happens and then conduct fresh elections. So it is not completely true that INEC cannot declare elections inconclusive. But however, if it must do it in accordance with the law and not without taking due cognizance of what the law says.
Mr. Agim, let me ask you this. You said that this is the first time we're having such a huge number of polling units where rerun elections are supposed to hold and all of that. What do you think is responsible for that? In the light of the fact that this huge number means huge resources from INEC again, what's responsible for this huge number of cases for rerun elections?
Well, unfortunately, we all know that elections in our clime and those who seek political office in our clime see this as the means to an end. Most persons today who contest elections, particularly those who have the wherewithal, the resources to contest elections presently, are those who see this as a means of livelihood. Most of them don't actually have anything to fall back on. So they see it as a do or die, and they employ every tricks in the books to ensure that they get into office. And so by so doing, they use every antics to make sure that particularly in areas where they know they don't have relative strength or comparative advantage as against their opponents, they cause all kinds of tricks to ensure that elections in those polling units are declared cancelled. And that way, maintaining a stronghold in their own areas where they have control, and then at the end of the day, they garner the highest number of votes and they are declared winners of those elections. So basically that's it. But of course, like we all know, if the Mr. President had done the needful by signing the 2018-2019 electoral amendment bill that was sent to him to law, I'm sure some of these issues would have been mitigated, because it would have been mandatory that, for instance, where violence occurred, elections there will be cancelled, and then there will be strict adherence of INEC to ensure that elections in that place is conducted with the use of the card reader. But unfortunately, that did not happen, so we are faced with the fate of where some of these politicians use every antics in the books and every trick to ensure that these elections are cancelled, where they know they don't have strong massive support of voters from their constituents, and then they tend to get away with it.
Let me ask you as well, because from your concluding statement there, what then can the NJC do in this kind of situation? Let's say, for instance, the collation of results and the announcement of the results is already on the way, and then the judge goes ahead to give an ex parte order stopping the process.
Yes, Gimba, to see, like I said, the law is clear. Section 26 of the Electoral Act, it's clear on how this can be done. Like I said, Section 53 mandates the INEC to declare elections inconclusive when there are issues that borders on electoral violence and what have you. But Section 26 equally makes it clear. I know I've had a lot of colleagues cite Section 87, sub 11 of the Electoral Act that the court cannot stop elections or election processes. But you see, in Section 26 is clear, it states clearly that where elections are cancelled for whatever reason, INEC can on its own, like some instance where we had of a case in Adamawa, in Bauchi, where we learned that INEC discovered that there were mistakes in the number of figures that were written to tabulate the total number of votes scored. And then INEC had decided that they were going to go back and do a final collation, having realized that that mistake was made. Section 26, sub 3 of the Electoral Act empowers INEC to go back and do a final collation and declare a winner of that elections. But you see, it is the same Section 26, sub 4, that goes ahead to to provide that where INEC has made that call, whoever intends, Section 26, sub 5, provides that whoever is interested in that decision that INEC has taken can go to court, a competent court of jurisdiction, to challenge that decision. And when that is done, INEC is bound to hold the collation of that election until the final determination of that case. So I am happy that where we are right now, we are trying to enrich the actions of those who have decided to challenge the position of INEC or decision of INEC to go and do the final collation and do a return in the areas where they felt the call that was made earlier on was wrong. I'm happy that this person has decided to go to court, because before now, I stand to be corrected, I've not seen any judicial pronouncement as to whether someone should, or a contestant who is interested in that election, can go to court. But it's provided for under Section 26, sub 5 of the Electoral Act that whoever or a contestant in such instance where INEC had declared an election inconclusive and has decided to go ahead to do a return, having realized that the initial call was in error, can go to court and challenge it. And you see, our laws and our jurisprudence are being enriched by the pronouncement of the courts. So it is not out of place for those who have decided to go to court to challenge it. And I stand to be corrected. The law is clear. Section 26.5 is clear that whoever is affected can go to court. And
okay.
so all the parties and the dramatics personnel in this instance are all acting in accordance with the law.
Well, look at the implications of that. Are we reaching to the detriment of what? That's in a moment. Join us again. All right, Mr. Agim, for some of your colleagues, including the senior ones, who are of the opinion that this matter had already been settled, that it is the tribunal that can take a look at post-election matters, but for pre-election matters, yes, you can approach the regular courts. What do you think of that?
Yeah, okay, you see, Chamberlain, like I said earlier on, our laws are clear. You know, with all due respect to my most respected seniors and colleagues as well, like I said, you can check it. Section 26 of the Electoral Act is clear on this. Agreed that when matters that borders on elections comes up, it is the election petition tribunals that are meant to determine that. That is the general rule. But in this instance, where elections have not been fully concluded, and in concluding elections, it is clear that collation is the process and declaration, which is the final point, the legal act that INEC must take in the conduct of election. Until that is done, the process is not yet concluded. And in this instance, INEC has declared some elections inconclusive because of the reasons already adduced, which is within the law. And like I said, because the law provides for INEC to make a recall in the instance where they discover that the call originally or earlier made was wrong, a wrong call, INEC can go ahead and order that the return, the final collation be made and the return be made for that elections. But like I said, this is provided for under section 26.
Just pardon me. Let me jump in and ask you this. Now, yes, I mean, how is this going to play out when the law says, well, within 21 days, they've got to fix dates for the supplementary elections? Now, where collation or where the courts or they stop collation, number one, can they go ahead and hold supplementary elections if they don't know the results for which, whether or not they've met the required percentage in law or not? And how do they play around the 21-day window that the Electoral Act also gives them in that circumstance?
All right. I think, Chamberlain, it must be clear here that elections are declared, it is until after the final declaration of elections that the 21-day starts to run. It is not before. So that election was conducted 2 weeks ago and returns have not been made and declarations have not been made, the time will not start running. The time, the 21 days time stipulated by the provisions of the Electoral Act and the Constitution is after the declaration. So when declaration has not been made, that 21-day time has not come into effect.
All right, Mr. Johnny Agim, thank you very much indeed for talking to us today on the program. So, gentlemen, that's the show today. We thank you all for watching. We'll see you tomorrow. I'm Chamberlain Uso.
I'm Gimba Umar.
And I'm Ayo Makinde. Have a wonderful day.
The views and opinions expressed by guests on this program are those of the maker and do not reflect the views, opinions, and endorsement of Channels Television.